Thank you very much indeed for this fascinating lecture. Now we have half an hour for the discussion, for your questions and comments. Please, beginning from the left, where's the microphone?
Thank you very much for the sound.
No, there's no sound.
No sound. Thank you very much. No sound. Still no sound. 1, 2, 3. I'm sorry.
No, the translators can't hear.
Test. Oh, okay.
Thank you very much for a wonderful and thought-provoking lecture. I'm Joachim Savelsberg from the University of Minnesota. I could not help, when you made a little excursion into criminology, to think of the work of William J. Wilson. William J. Wilson is a very prominent African-American sociologist who studied poverty, studied violent crime, together with his colleague Rob Sampson. And William Wilson has often warned scholars to not avoid speaking about massive rates of violence in African-American impoverished neighborhoods, because he said we need to speak about them and not to leave this field to conservatives. We need to speak about them and then take the next step, which is study the structural conditions under which this violence occurs. In a way, in your terms, he talked about the killers, the perpetrators of violence, as victims of structural conditions of society, and thereby spoke to the complexity of the relationship between perpetration and victimhood. In a way, we have to do something similar, of course, when we speak about major mass atrocities. To take the extreme case of the Holocaust, how are we going to take the victims of the Holocaust and talk about them in similar terms in which Wilson talks about the relationship between killers in the ghettos and structural conditions that make them to what they are. So this is a very difficult question. The crucial question I guess I wanted to ask is how can we keep society from doing what you argued should not be done? How can we keep the Hitlers and Milosevic's from abusing history, constructing memories of victimhood that justify aggression? What kinds of institutions do we have to create in order to construct history in a more successful way that does not generate future violence and keeps cycles of violence moving forward? I didn't hear very much about these kind of institutional conditions that, or preconditions of that which you find desirable, and maybe you want to comment a little bit on that.
Thank you. That's a wonderful invitation. That's another paper. But let me just say it very briefly. I strongly believe that memory and conflict resolution have to go hand in hand. So the target audience for me are first and foremost are conflict resolution professionals. I think there has to be a real integration of historical perspective into conflict resolution when appropriate. Not in all cases, and not always. The past is not everything, but it's a lot. Now, so we need to invent new institutions. About 10 years ago, about 10 years ago, I started an NGO that had to do with what was called Institute for Historical Justice and Reconciliation, and we were bringing historians from two sides to try and write a shared narrative. Now, there are different practical things that can be done, but just like human rights, it's not just pointing out, that doesn't stop the Milosevic, the fact that there is a vibrant human rights community out there. We have to look at history and at historical dialogue as a political advocacy field, as one in which it's not a place, we're not going to go to, just like reconciliation. For years I was under the misleading impression that reconciliation can actually be achieved. There is no such thing. Reconciliation is a process, not a place. Historical dialogue is a process, not a place. We can work on it, and I would suggest as a short answer just to look at it as a form of advocacy, which includes everything that we know about advocacy, civil society, sometimes government organizations, wherever you can influence. But the first thing is to recognize that it is not something that is useless because we can't change the past. We change the past every day, with some limitations.
Thank you. Lavinia?
Thank you, Elazar. I wonder whether you can comment on how your theoretical framework applies to 3 cases from Eastern Europe.
Okay.
One of it is what Cosmin after lunch or before lunch, he mentioned this thing that we have instances of victims who are victimizers in Eastern Europe, victims of communism who are victimizers in the sense that they were connected with the Nazi regime, Then the second case I was thinking of was the case of the tenants, people who are living in confiscated apartments. Sometimes they buy them, and they are doing that at the expense of the initial owners who are, So again, and the third case, we didn't talk about it until now, is the former secret informers, who some people in Eastern Europe, in some countries at least, see as victims in their stead because the initial recruitment was the result of some kind of pressure applied by the secret services, So they were, again, victims and victimizers at the same time. And I wonder whether you can comment, on these cases.
Sure. Some questions are easy. So the first thing is, and that's what I'm trying to say, is that we should, and it's an impossible task, but it's an easy answer, is to divorce victimhood from a moral quality. So the challenge, why do we find it challenge those questions that you raise? Because once we categorize it as a victim, we think that they are morally just. And we are pro-victims. And now I don't want to blame the victims, but victims are not equal, just the fact that they fall in the same category. So the first thing, and I'll actually use the 3 categories, the 3 examples that you used. I'll start with the last one. And instead of using your example, refer to the attempt by ex-NKVD, by families of ex-NKVD's officers that were then killed to be recognized as victims, as survivors and of victims of the state. So yes, they committed, there's ample evidence that they committed enormous amount of crimes. I mean, I'm talking of specific cases, not as an abstract. But then they were killed in a second round, in the next round. And now the states, when there was rehabilitation, wants rehabilitation of their member of the family. Now, this can be, I'm not going to adjudicate it, obviously, that's not my role, but the case is in this instance is to recognize that even if one recognizes as a victim of certain atrocity or certain violence, that doesn't endow the people with any moral claim. That's the most challenging because, as we said, for the last 2,000 years plus, we see victims as moral agents. The second example is actually what I referred to, the tenants, is an relatively easy one, because they may be the beneficiaries but not the perpetrators. So unless you yeah, but that's okay. So there's in that regard, the whole issue is becoming more complex because they are perpetrators or they are complicit in perpetrating crimes that are generally in the society, not in particularly getting that apartment. So there's a divorce. So again, how do you bridge the crime in one category with being victim? They're not victims, but they are beneficiaries in another one. So that, I think that what was said in both panels, the difference between compensation, restitution, different forms, and that's actually in the book that the No Refuge, No Return, one of the issues that the big difference that we are making, the big distinctions we are making, is what form of redress can you take into account not only the crime, not only the loss, but also in order not to instigate further violence. And the first example was the Antonescu, is that? Well, that's, again, this is, this goes back to the, similar to the NKVD. It's, it depends, I mean, as long as we don't see Ceausescu was a victim, so to speak, at the very last moment. In 99.99% of his life, he was a perpetrator, and then in the last second, he gets into a victimhood. So,
thank you.
Thank you very much for this fascinating talk. In a way, what you described is one of the consequences of increasingly talking about international relations in the language of criminal law, right? And you've made the parallels to domestic criminology. So there are good things about it, and there are bad things about it. One of the things is that domestic criminal law has never been good at resolving conflicts. It's been good at putting people in prison, which we know doesn't do anything good for anybody in particular, right? But that critique hasn't really made its way to international human rights and international criminal justice in a way that it probably should. So there is then a question of other languages, right? Because criminal law, as we just saw with your nice partial refusal to be judgmental, criminal law and the specific language of victimization that we have is incredibly judgmental. That it's even if you get half a point more, then suddenly you'd have your apartment or you don't. And on the other hand, global power inequalities are rarely thematized. So I'm just wondering if we can find languages for talking about things that make it hard for people to share societies together, like things that really stand in the way in terms of resources, in terms of, and histories, but not only, that are not so incredibly judgmental, because as we also know from other conflicts, being very judgmental is often not very good for solving conflicts. And one scholar who's brought that up is Wendy Brown, and her critique of, it was in this case of affirmative action, in the sense that referring to these wounded identities, you shouldn't blame the people who do that. Like, it's another form of victim blaming, but we are creating a society, or we're creating kind of a global society in which you get something from making those claims. So in a way, we're all complicit in the fact that that these languages are being used in order to get something in a world that is highly unequal. So in a way, you can't really blame people for trying to do that. So I think my question is, other languages, should we get away from this being very judgmental in having this criminal law language?
Well, I think that the incorporations or the adaptation of the language of criminal law to in transitional justice, the question is problematic, as you point out. But I think that the response to that is to include much more attention, and that's why my focus is on conflict resolution, is to include the questions of mediation and the questions of arbitration. The difference between domestic and international, or the domestic and intergroup relationship, is that while in criminal law, once the situation is resolved, even if it is done in an unjust way, the memory of that is not perpetuated to the next generations, and therefore it is over. Eventually it's over. Even in that regard also, one of the things that I don't believe that we pay attention to in this conference because of the regional specificity of it, but there is an enormous difference between conflicts that include identity and conflicts and transitions that don't include identity. So I think the language in places where when it includes identity has to include shared narratives. And I can talk a lot about shared narrative, but basically there is a real need for advocacy, I believe, that would bring the two sides to formulate some kind of an alternative language, as you say, that actually counters the nationalist narrative and show empathy to the other side. It won't be dominating, the textbooks would still be different, but at least we need to make an initial effort to push that kind of work forward.
Thank you. Please.
You have a question.
Dziękuję bardzo.
Thank you very much. Mr. Professor, in second part of your presentation, you have outlined a vision of constructing a narration impartial to some extent, which could be developed and based on interdisciplinary dialogue by, as you said, if I got you right, by impartial scientists, by scientists not tainted by ideology. We are also trying, as the network, as the European Network Remembrance and Solidarity, we are trying to do the impossible. But my question is, where to find such people? Is it possible at all? Is it realistic? Thank you very much.
So first of all, thank you for the opportunity to clarify what I said. But what you mentioned about the work of the network is the very reason that I'm here. Because that's exactly what I want us to do. That's exactly what I want to establish more relationship with it. That's exactly what's behind us on the screen. It's exactly that. What I do want to clarify is that I didn't say impartial. I said in subjective. I tried not to say impartial. I may have made a mistake, but I don't mean impartial because I don't believe in impartiality. What I believe is in intersubjectivity, which means that I'm willing to create some kind of a text, some kind of a narrative that actually brings together and take into account the different perspectives. So I don't think that at the end of the day, you're going to get to rely on someone and her ability to produce a superior narrative that everybody would come under their wings. That is not realistic and it's not advisable. However, if you can create, in the case of the network, if you have a group, you have five member countries, if you can get a historical group of all of those to discuss issues that are pertaining to all of them, more or less conflictual, and produce a document that is agreed on all the members, that's an enormous advantage. Eva Clarita spoke earlier today about the retrospective justice, you called it? Yeah, but in any case, about not the Truth Commission, but the Historical Commission in the Baltic States. So I think that's a great instance where there were failures, where there are better attempts, but it's to take account, in this case, of the international community, of absent people, of people who were members and were stakeholders if they were not expelled or destroyed, to bring them all together into some kind of a negotiation. Mostly it's done badly. At least the goal is that it can be done well. And there are different examples of that. There are many examples in textbook commissions. There are several examples. In Poland, you know much better than I do about the German-Polish examples. There's a Czech-German example. And those individuals, in occasional cases, actually become even advocates or participants in political crisis, in a moment of political crisis, as was the Czech case with the accession. So I think that this network, and that's go back to, you have an enormous challenge, and I really hope you'll do it excellently.
Thank you.
Yes, Elazar, I'm not sure I understand what you mean about the conflict you see between
I'm sorry?
The conflict you...
Yes.
Yeah.
The conflict you see between historical dialogue and conflict resolution experts, because I'm not sure I understand still what you mean either by conflict resolution or historical dialogue. Let me tell you what I mean. With respect to conflict resolution experts, perhaps I misunderstand that. You haven't really told us, I think, who or what theory of conflict resolution you have in mind. I'm going to assume for the moment you mean something like dispute resolution and the getting to yes style of dispute resolution that's been so influential and adopted by conflict resolution folks in diplomacy in particular, for which Roger Fisher initially had his theory in mind. And that approach to conflict resolution, in the underlying theory is you can take a large historical dispute or a contemporary dispute with historical dimensions to it and break it apart into little pieces. So you can get agreement, you can get to yes on little parts of the dispute, and you work on them individually, and then you can work your way towards a satisfactory resolution. You used the word negotiation as well recently, so I again assume, since that's a theory of negotiation primarily, that that's the kind of conflict resolution you have in mind. With respect to historical dialogue, I have a better sense of what you mean, but I'm still uncertain from your response to the last question. Okay, let's say you get both sides to a historical and contemporary conflict at the same table. They each show one another their documents, and they can agree on this forensic truth, as it's sometimes called, that these documents are real, they're not forged, they have some relevance to this dispute. But you've acknowledged that you can't get around the issue of interpretation. There will be differing interpretations of the same document, once acknowledged forensically to be valid. But those disagreements of interpretation go to the core of how to resolve a dispute if you insist on making historical dialogue part of the solution to the problem. And it's precisely this insistence on bringing historical dialogue, which requires entails these differing interpretations of the past into the contemporary resolution of the problem, that reinstates all the problems to which conflict resolution theory and negotiation theory in the getting to yes tradition was designed to avoid. I hope I've been clear.
Okay. Thank you. So, conflict resolution. Actually, you understand. You may disagree with me, but you seem to, from your description, to understand very well what I mean by the category. So that's given. Yes, in certain instances, conflict resolution. You need to stop. I'm not talking about Syria. Syria is not a place at the moment to speak about. It's to stop the killing. It's not to resolve historical conflicts in Syria. But when you have a peace process that goes on for decades, or when you think about conflict prevention, or when you think about responsibility to protect, or when you think about Rwanda today and the outlawing of teaching of history, or when you think about issues that between Croatia and you think about regional truth commission that should actually be regional historical commission in the Balkans, when I'm saying that we need to avoid conflict, historical investigation, historical dialogue aims for the long durée. It doesn't mean, I'm not talking about stopping the fighting and writing a memo of, so I'm very mindful that if you look at the Israeli-Palestinian conflict, right, I mean, you can't wait for the conflict to be over to start historical negotiations, but clearly understanding the 48 and mediating the different perspectives between the two sides can be done and is being done while the conflict is ongoing. So there is a lot of advocacy on it when the conflict is ongoing. It doesn't resolve the conflict immediately, but it does. But that negotiation or that historical dialogue over the 48 catastrophe from the Palestinian perspective and independence from the Israeli perspective does talk about greater empathy for the victims. It raises the awareness in both societies about this. So I have a colleague now, or no, it's not I have a colleague, but I spoke recently to a Palestinian who was trying to introduce Holocaust educations to the Palestinians. That is the essence of historical dialogue. It's not something that's going to be resolved. He fully acknowledges what's the challenges. The same thing is talking about the Nakba, the catastrophe of 48 in Israel. The same thing in Hindu and in Muslims. We can go society by society. What I mean is that just like human rights advocates, you're not pointing to a violation and you resolved it. You need to establish a culture that will facilitate this kind of approaches over a period of time. So that's the challenge. We can talk about the details.
Thank you. Yes, please.
I have a question to both the speaker and the chair, and I hesitate a little bit, but I will try to ask anyway. What do you think, who is responsible for healing the suffering or victimhood of of suffering or victimhood of German expellees, or who should be a partner of this process?
You want to take it? It's your area? I'll pitch in, but...
Well, is anyone responsible for healing of someone else's pain? I don't see it, except for the perpetrator, maybe morally. Who can make it? That's another question. I suppose that when you think of, let's take the specific case of the German expellees from the territories which make now part of Poland. It's been an incredibly successful story, exactly based on a long process of forming a language in which parties to the conflict can express their own history in the same room, which started basically in the 1960s. It took 40 years and made a great progress. And I have no idea, did it contribute to the healing of suffering or wounds? This I don't know, okay? But I know that it created a space in which people who still disagree may share a story of the Second World War. And I would rather ask the question, what were the conditions that made such dialogue about the Polish-German past or Polish-Jewish past different to the dialogue on Polish-Ukrainian past, which was much less successful than the first two. And we actually see a regression in it. And what I see is, from the point of view of a historian, which participated in a part of this discussion, is what Professor Barkan is calling for historians and other people involved in the kind of studies that we are making here to make an additional effort to take into consideration one more aspect of the stories we tell. It doesn't contradict the basic mission of a historian, which you can express with a traditional sentence of pursuing a truth. Not at all. We just make it more difficult. Which is great, because anyone who is a scholar loves intellectual challenge. That's the job for us, simple stories, I hate people who say, I want to commemorate the victims, and then what they make is a cheap monument made out of concrete rather than bronze. Cheap, fast-made, low quality, next generation will be ashamed of it. So this call is not only justified as a proper contribution to the conflict resolution, which was your rationale of it. For me, it has a value added of furthering the progress of historiography,
Absolutely.
Which will be more difficult to write, but more accurate also in this sense. So this is my bad answer to your question. I don't know what is your answer.
I don't know about, I said in the paper, I don't know about healing. It's a little difficult, but the question is, I think that with the German expellees, there was a problem. There was the difference between those who were expelled from Silesia and those that expelled from the Sudeten. And part of the difference is the political aggressiveness of the expellees organizations. One of the reasons that the differences between Japan and Germany is so big with the regional relationship is the willingness of Germany to atone. And I think that was very much lacking with Sudeten Deutsch. So I think that healing is really part of a process that involves all sides. You can't both just claim to be a victim and not show empathy or recognition of your responsibilities, but to try and emphasize a very subjective nationalist perspective. That's not going to wash with the other side, that's for sure. And that also answers to some of the questions of other conflicts that are not that don't gel so well, is because the subjective, the sectarian, I'm always saying partisan, the sectarian perspective is really problematic for this kind of perspective discussion.
Panie profesorze Elazar.
Professor, two short issues. How a community should behave, I mean a community of academics, political scientists, if there are conflicts that cannot be solved. Last year I went to the Holy Land and I admired it. I was very much bothered by the wall in the middle of Jerusalem into the dirty Palestinian and the clean, the Jewish one, and I asked how to and asked whether this wall deteriorates this conflict or ameliorates it, perhaps. And a professor from Jerusalem University said that the wall would last for much longer than the Berlin Wall had. And the other issue, Professor, it is about a solution, because Israelis want to reconstruct a Jerusalem shrine, but without bringing down a mosque, it is impossible. And then, who had come up with the issue of statutory limitations? Was it specialists of penal law, of criminal law? Why it pertains only to some crimes and not to all? I would like to hear your opinion.
I hope that I understand the question correctly. Your two examples of some Israeli perspectives on the conflict with the Palestinians represent a nationalist perspective that I don't think people with liberal views support. So I'm not sure exactly what to say, whether to call it I don't know who knows how long the wall would last. I don't have anything to add to that. Maybe more, maybe less. It's clearly a subject of political conflict, and the mosque is even more horrific, obviously. So I don't know what to say about it. As to regard to statute of limitations, some crimes are viewed as those that are not subject to statute of limitations, and others are yes. Is it morally better this way or another? I'm sure that it's subject to debate, but it's at the moment that's what it stands like. There's no reason why it should not be changed if the politics would see it differently. Some people see execution as violations of human rights, even when it's done with criminals of the most horrific crimes. There's a big state that I come from that largely validates that. Is it morally right? No. So justice and morality are not the same.
Because we are approaching 8 o'clock, this is the last question, I suppose, today.
Dear Professor Michał Kutoszyński, Adam Mickiewicz University, Poznań, Poland. Thank you very much for this wonderful lecture on victims and perpetrators and building this shared memory and shared history. What I wanted to ask is that one thing is history that is constructed through the negotiation process by the historians, and the other type of history is a history that is constructed through legal procedures, such as criminal trials and administrative measures such as lustrations. And this legal truth is derived, its power is derived from the legal norms and not from the negotiation process. And my question is whether this type of legal truth fits somewhere in this scheme that you presented here.
Your question is
whether this type of truth, this legal truth, fits within the scheme, this model that you presented here.
So, legal truth, or truth that is established by legal bodies, is something that is completely different from truth. It is subject to procedures, to legal procedures, to process, to courts. It is final, and you get a verdict. That's the truth. As we heard earlier today, the connection between this and memory is very critical because it becomes a factor of the public memory, the historical memory. But we shouldn't confuse it with actually truth. And by truth, and that's what I said, I invited the questions about truth. So I'll just take another 2 minutes for that. The right to truth is presented in international norms and by human rights and by others as a positivist right, as one that you can actually get something that you would call truth. But this is obviously nonsense, excuse me to be brutal, because truth is something that is mediated, that is continuously changed, that once you get it, you immediately have new information that keeps changing it. So I think it's not that there is no truth, but truth is something that is provisional. It's like what I said about reconciliation. It's a process. So in that regard, scholarly truth, no historian, I don't know of any historian who writes a book that thinks that their histories will never be revised. So, but they still not try and write an inferior book. They want to write the best truth that they can at a particular moment. So the same thing is this. There is a dialectical rather than a dialogue so much. There is a dialectical relationship between legal truth and historical truth or political truth. And it's one form of the discourse that contributes to public opinion of what constitutes a legality of the legal truth. When the International Court of Justice absolved Serbia of responsibility for the Srebrenica genocide, that was a failure, although it succeeded as a verdict, it was totally rejected by the international community, by the public. So it's not always that the court has the final word. In fact, many cases it doesn't, but it is an important factor. Actually, there's a good book which I like a lot on the subject by Richard Wilson on the ICTY and the historian that contributed to the historical process by the ICTY. And I think that if this question is of interest to you, that's very worthwhile, because he shows a lot of the limitations of the historian participating in the process, although the ICTY was one of the spaces, the legal spaces where it was more open to historical intervention.
Thank you very much, and thank you again for this fantastic lecture this evening. I have an announcement. The organizer asked me to invite you for a dinner which is right across this door on your left. So you go around and the dinner is waiting for you. Thank you.